Okay, Pat.
Hi, good morning, everyone. Thank you for taking time to attend today's webinar, to dial in. Sorry about the slight delay in getting things started. My name's Pat Shea. I'm a partner at Cordium, a firm that I'm sure many of you know provides outsourced compliance support to our clients. And part of what we've done through the years is keep an eye on anti-money laundering programs. And that's really the main topic for today, together with my colleagues Wendy Torres and Sabrina Barilli. We're going to be really talking through the impact of FinCEN's proposed rule, which would impact the anti-money laundering programs for investment advisors and would bring the SEC into the picture in terms of overseeing those anti-money laundering programs. Wendy and Sabrina have been with Cordium for over 10 years. They've each been with Cordium for over 10 years, and they're both members of the Association of Certified Anti-Money Laundering Specialists, or ACAMS, and they are leading our effort, Cordium's effort, to make sure that all of our investment advisor clients are informed and certainly prepared if and when this proposed rule becomes effective. In terms of, I guess a little bit of housekeeping just to make sure people are familiar with the system. If you have any questions to submit during the webinar, you can go to the GoToWebinar application and enter your question there. I think you can see it on the screen now. If you want to submit those, we're going to try to leave a little bit of time at the end. We're going to go for about 45 or 50 minutes total, so we'll try to leave a few minutes at the end to respond to those questions. If we don't get to any questions today, feel free to reach out to any of the three of us after, and we'll do our best to get back to you as quickly as we can. You can see the agenda for today's presentation is outlined here. I won't go through it in too much detail, but certainly there are anticipated impact to those listeners who are registered investment advisors. Sabrina is going to give us an overview of what FinCEN has proposed, a little bit of history, and also just walk us through what the proposed rule, and then Wendy and Z will dive into some of the details. Wendy's going to talk about what it means to establish or perhaps expand your anti-money laundering program under the rule, talk about suspicious activity reporting, the impact to currency transaction reports, record keeping, the travel rule of the Bank Secrecy Act, and Sabrina is going to go through some of the implications around information sharing, some historical AML case studies and audit findings of other regulated financial institutions, which I think you'll find helpful as a little bit of precedent or a little bit of history, and then some possible future additions by FinCEN on the proposed rule, as this is still a fluid situation given that the rule has not yet been deemed effective. And then toward the end, I'll come back on and just try to do a little bit of recap of things that we've gone through and also try to give some practical feedback in terms of what you can be doing today and in the ensuing months to look at the rule, see what your anti-money laundering program looks like today, and what sort of tweaks you may need to make in anticipation of the rule. So I guess lastly, for those of you who may not have had an opportunity to look at the proposed rule, you can go to fincen.gov and you can go to their website, you can get a look at the rule. So without further ado, I'll turn it over to Sabrina to start working through the agenda.
Thank you, Pat. I'm sorry we're having a little bit of technical difficulty. Just bear with us one moment, please. All right. Thank you again, Pat. Hello, everyone. My name is Sabrina Barilli, and I currently oversee Cordium's due diligence service line, which includes the enhanced due diligence and watch list screening and reporting for AML purposes. As Pat mentions, I'm going to be providing you with a brief overview of FinCEN's most recent proposal and the regulations that are required by registered investment advisors once the rule becomes final. But before we get to that, I just wanted to go over a couple of the abbreviated terms that you're going to hear us talk about throughout the presentation. And most of these should be very familiar to all of you, but just for the sake of clarity, I wanted to go quickly over a few of them. AML, obviously, anti-money laundering, it's a set of procedures, laws, and regulations that are designed to stop the practice of generating income through illegal actions. BSA, Bank Secrecy Act of 1970, which requires financial institutions in the United States to assist government agencies in detecting and preventing money laundering. CDD, customer due diligence. This is required by the money laundering regulations to better identify suspicious transactions and to know your customer. CIP, customer identification program. This is a requirement where financial institutions need to verify the identity of individuals wishing to conduct financial transactions with them, and it's a provision of the USA Patriot Act. CTR, Currency Transaction Report. This is a report that the U.S. financial institutions are required to file with FinCEN for each deposit, withdrawal, exchange of currency, or other payment or transfer by or through the financial institution, which generally involves a transaction in currency of more than $10,000. FinCEN, Financial Crimes Enforcement Network. This is a network administered by the United States Department of Treasury, and its goal is really to prevent and punish criminals and criminal networks that participate in money laundering. RIA, Registered Investment Advisor. This is an advisor or a firm that's engaged in the investment advisory business and registered either through the Securities and Exchange Commission or state securities authorities. SAR, Suspicious Activity Reporting. One of the tools that's provided under the Bank Secrecy Act as a way of monitoring suspicious activities that would not ordinarily be flagged under other reports, such as a currency transaction report. SEC, Securities Exchange Commission, government commission that's created by Congress to regulate the securities market and to protect investors. And lastly, STR, Suspicious Transaction Reporting. This is information that's generally demanded by the Internal Revenue Service from banks and other financial institutions regarding suspicious transactions. If there are any other terms I have not covered, please feel free to advise us during the question and comment section, and we will further address. At this time, I'm going to go over the history of the proposed rule, and it's been a long history. As some of you might be aware, this is not the first time a rule has been proposed requiring that registered investment advisors implement AML programs or that they comply with suspicious activity reporting. In 2002, FinCEN had first proposed to extend AML programs and requirements to private funds. In 2003, they sought to include investment advisors. However, after a lapse of time, both of those proposals were withdrawn in 2008. Back again to 2015, FinCEN decided they were going to repropose the rule and seek to replace those prior withdrawn rules and apply them to any sort of registered investment advisor with the SEC. It does not apply to investment advisors that fall within an exemption from SEC registration, such as those firms that rely on exemption, say venture capital fund advisors, or the exemption for private fund advisors managing less than 150 million from a place of business in the US, the exemption for foreign private advisors, or family offices relying on Rule 202, or commodity trading advisors whose business is really not predominantly securities-related advice. Since those prior proposals, there really has been some sort of noteworthy regulatory changes for investment advisors. As you all know, under the Dodd-Frank Act, the Investment Advisors Act of 1940 was amended, and previous categories of unregistered advisors, such as investment advisors to hedge funds and private equity funds, are now required to register with the SEC. So according to the new proposed rule, those covered registered investment advisors would become subject to the Bank Secrecy Act rules. and certain portions of the USA Patriot Act. We're going to further discuss the USA Patriot Act when we review information sharing requirements under the proposal. So what does FinCEN's proposed rule entail? Let's begin with just a general overview. Under FinCEN's proposal, registered investment advisors, or those required to be registered with the SEC, would be included in the general definition of financial institution. This includes advisors to certain hedge funds, private equity funds, and other private funds that are subject to the rules under the Bank Secrecy Act. The rationale of FinCEN is that investment advisors contemplated under this proposed rule, they're really similar to the investment services and use similar financial products as those offered by those that are already covered under the rule, such as broker-dealers and securities, banks, mutual funds, insurance companies. Additionally, the proposed rule does seek to require that those investment advisors establish and administer AML programs, that they report suspicious activity to FinCEN pursuant to the Bank Secrecy Act, that they file transaction reports and comply with record-keeping requirements and the travel rule of the Bank Secrecy Act, and that they adhere to the information sharing request under Section 314 of the USA Patriot Act. FinCEN anticipates that authority generally to determine compliance with these requirements will ultimately be delegated with the SEC. So when does this rule take effect? The requirement to establish an AML program would become effective 6 months from the date a final rule is issued. And that's anticipated by many to be sometime this year. Some say as early as this summer. The suspicious activity reporting requirement would only apply after the AML program is already implemented. So noting that, it's safe to say that it's prudent to start planning for this new rule and this AML requirement now. So why regulate the SEC investment advisors? Well, according to FinCEN, these investment advisors are on the front lines of a multi-trillion-dollar sector of our financial system. And FinCEN's really just seeking to deter money launderings from seeking access to the financial system through financial institutions like these investment advisors that are not required to maintain AML programs or file suspicious activity reports now. Other financial institutions, again, like the mutual funds, the broker-dealers, the banks, the insurance companies, they already comply with the AML and the Bank Secrecy Act. So they're better equipped and in a better position to identify and prevent unlawful activities like money laundering or terrorist financing from occurring from those who really are seeking to remain undetected. Once finalized, once adopted, the investment advisors will need to amend their compliance manual or any sort of offering document or disclosure material to address these new AML requirements. It's also important to maintain appropriate records in accordance with the requirements of the Bank Secrecy Act. So for those registered investment advisors that may already be subject to an existing AML program, you'll just need to make sure that it's compliant with all current requirements of the Bank Secrecy Act and the new rule. At this time, I'm going to pass this presentation over to Wendy. She's going to further discuss the AML program. She's also going to review the reporting and the record-keeping requirements that are currently under review with the proposed rule.
Thank you, Sabrina, and hello, everyone. As Sabrina mentioned, I'll be discussing some of the requirements proposed by the rule. I'm going to start off with the AML program and touch upon the different reporting requirements as well as the record keeping and travel rules. Now, some of you may already be familiar with most of these requirements, so this will be a refresher for you and hopefully a useful tool to get the rest of you started. So before even getting into the details of the AML program, I'm going to briefly discuss risk assessment. FinCEN recommends a risk-based approach to designing an AML program. This essentially gives advisors the flexibility to create a program that meets their specific risks and those posed by their advisory services. And there are two types of risks that advisors should assess, and that's business and regulatory. Business risk can be assessed by evaluating the type of client, their geographic location, as well as the types of products and services provided by the advisor. The second type of risk is regulatory risk, and this is simply just monitoring regulatory and legal developments and making sure that your AML program addresses these. Advisors must also be especially adamant about reviewing new products and services before they launch so they can determine the level of risk that they pose. Now, while there are many other factors to consider when assessing money laundering risk, a focus on business and regulatory risk can serve as a starting point for advisors. Now, let's get into the details of the actual AML program. FinCEN discusses their expectations regarding specific types of services. However, in this webinar, we're just going to discuss the general minimum requirements of an AML program. The program should have three basic things in mind, and that's to prevent money laundering and terrorist financing, to report suspicious activity, and to train employees on the legal and internal procedures that must be followed. As mandated by BSA regulations, an AML program must include 4 elements. And these 4 elements are policies, procedures, and controls, a designated compliance officer, a training program, and independent audit to test the program. And I'll briefly discuss these 4 elements in the next few slides. We'll start with policies, procedures, and controls. Policies can be designed around firm-wide policies and relevant laws and requirements. They should be revisited at least annually and updated to reflect any changes in regulations along with changes in the firm's risk profile. Procedures can be specific to a product or service, and they can be modified as needed in response to changes in risk. Firms should also make sure to provide sufficient controls and systems for timely detection and reporting of suspicious activity. So next, I'll discuss the need for a designated individual to manage the program. The firm should designate an individual or a committee responsible for implementing and monitoring the operations and internal controls of the AML program. This person or committee should review deficiencies, train personnel, and keep everyone informed of any changes to the program. They should also stay current on all legal and regulatory developments. Firms with more resources and personnel can essentially divide some of these tasks, but the overall responsibility for designing and implementing the program should rest on the designated compliance officer or person. Now, when it comes to training, a lot of firms aren't quite sure about who they should train and what they should address during training. According to FinCEN, those employees whose duties bring them in contact with BSA requirements or possible laundering activities should be trained as soon as they assume those duties. These can include client relations personnel, the investment team, compliance staff, and even senior management. Training should include general information on money laundering, some of its implications, and how to identify any red flags. The firm's customer due diligence policies and procedures should also be addressed, and they should also touch upon the record-keeping requirements and the process for filing and reporting suspicious activity. Training should take place periodically or whenever deficiencies or new developments are identified. The material or topics should be relevant and easy to comprehend, and attendance should be tracked. So now let's move on to the next element, which is independent testing. And testing should be conducted annually by an outside company or by employees not directly involved with the program. The employees or individuals testing the program should be familiar with BSA requirements and have a good understanding of any risk factors. The ultimate goal is to test the effectiveness of the program. In the next slide, I'm going to discuss some of the items that the audit should address. The audit should evaluate the adequacy of the firm's AML risk assessment, the effectiveness of CDD policies and procedures, personnel adherence to these policies and procedures, training, compliance with applicable laws and regulations, systems designed to identify suspicious activity and generate reports, and record keeping and information management. All findings and recommendations addressed by the audit should be documented, and deficiencies should be addressed immediately. The board of directors should also be kept informed of all audit findings, deficiencies, and any plan of action for addressing those deficiencies. So next I'm going to shift gears and go over the second requirement. Suspicious activity reporting provides useful information for investigations in cases involving money laundering, terrorist financing, and other financial crimes. The process for identifying and reporting suspicious activity should be risk-based as well and determined by the firm's size, the business, the type of customers that they have, and the products and services offered by the advisor. Procedures and systems should be in place to help monitor, evaluate, and document suspicious activity. So whenever you do encounter suspicious activity, a formal evaluation must take place and be memorialized. The reasons to file or not to file a SAR must also be documented. So for example, if you identify suspicious activity, but after further evaluation determine otherwise and decide not to file a SAR, then your reasons for not filing a SAR must be documented as well. FinCEN also discussed the money laundering red flags likely to be observed by an investment advisor, and I'll discuss that next. These include clients exhibiting concerns over government or currency reporting, any reluctance to reveal information about their business activities, who they are, where they live, who the beneficial owners are, amongst many other factors. Any unusual transaction activity not consistent with investment objectives is also considered a red flag. Avoidance of normal documentation or very little concern over loss or risk should also raise some red flags. And these are just a few. There are plenty of other red flags to keep in mind. Next, I'm going to discuss when FinCEN recommends a SAR to be filed. FinCEN suggests filing a SAR for suspicious transactions that involve an aggregate of at least $5,000 in funds or assets. Exceptions for transactions less than $5,000 can be made if the transaction involves funds that are suspected to be derived from or used for illegal activity. After you've identified these suspicious transactions and conducted an evaluation, then you file the SAR. And a SAR must be filed with FinCEN 30 days after becoming aware of the suspicious transaction. All records and reports associated with the SAR must be kept on file in case there's an investigation. FinCEN also urges advisors to report any suspicion of terrorist financing or money laundering schemes immediately to law enforcement and to also subsequently file a SAR. So now we'll go into the details of the CTR requirement. And this is another requirement that may be new to most. The currency transaction report will be replacing the Form 8300 and will need to be filed for transactions of more than $10,000 in currency. This threshold applies to a single business day. So for example, if during a particular business day there are several transactions from the same originator that aggregate to $10,000 or more in currency, then a CTR must be filed. Although the CTR doesn't cover every negotiable instrument covered by the Form 8300, FinCEN anticipates that the SAR filing requirement will mitigate any additional risks. The next requirement involves some rules regarding transmittals, and it may also be new to most of you. Whenever an investment advisor acts as a financial institution sending or receiving funds on behalf of another party, they must keep records of any transmittal equal to or exceeding $3,000. These records must include the name, the address, and the account number of the transmitter, as well as any payment instructions and the name and address of the recipient. This information must travel along with the transmittal to the next financial institution. And as for the record retention period, the investment advisor must keep records of transmittals for up to 5 years, especially records of those transmittals that involve any extension of credit of more than $10,000 or any cross-border transfer of funds that exceed $10,000. Well, that concludes my portion of the presentation. I'm now going to turn it over to Sabrina, who's going to be discussing information sharing, as well as some of the case studies and potential additional future requirements.
Thank you, Wendy. As previously mentioned, the proposed rule would subject registered investment advisors to information sharing obligations of the USA Patriot Act, and hopefully this will assist in their Know Your Investor due diligence of investors and others. So what's under the information sharing requirement? We'll start with one of the mandated rules. So this would be Section 314A. Under 314A, via a secure website, law enforcement agencies are authorized to request through FinCEN that financial institutions, and under the proposed rule, this would include investment advisors, that they search their records for accounts or transactions conducted with a person suspected by law enforcement agencies of engaging in terrorist activity or money laundering. If located, the financial institutions must provide identifying information on the requested person. This is not optional. In order to share the information with FinCEN, the process requires that the investment advisors review the FinCEN list of persons that are suspected of being involved in money laundering or terrorist financial activities against accounts maintained during the past 12 months and transactions that are carried out over the past 6 months. The FinCEN list of persons is generally issued about once every 2 weeks. If the advisor identifies that an investor account or a transaction record with the listed person, the advisor would be required to report such activity to FinCEN within 10 days of the request or 2 business weeks. So Section 314B, what is involved under that? Under Section 314B, the rule is extended to investment advisors that may register annual with FinCEN in order to participate in the information of sharing with other financial institutions. Again, this is the banks, the broker-dealers, the mutual funds, those financial institutions that are already subject to the AML program requirements. The sharing of information under this portion of the rule involves voluntary participation. It would permit an investor, an investment advisor, to go beyond public information and to make and receive requests and limited information on investors and others from other registered financial institutions that may assist in identifying potential money laundering, terrorist activity, and any other reportable suspicious transactions. The sharing of this information, it is protected, and it's via limited safe harbor from civil liability. So now the fun stuff, the AML enforcement actions. As briefly noted under the proposed rule, FinCEN has delegated authority or will be proposing to delegate authority to examine these registered investment advisors' compliance with the new Bank Secrecy Act requirements to the SEC. And these registered investment advisors covered by the proposed rule would be subject to SEC examination and possible enforcement actions if they are not compliant. So as we've seen with other financial institutions that are already subject to regulatory oversight, failure to comply with AML requirements would result in fines and monetary penalties. All right, so let's review a prior enforcement action involving another financial institution already covered under the rule. Some of you may be aware of this. It just occurred as early as last month. The SEC had reported that brokerage firm ES Financial Services, which is now known as Bicknell Global Markets, that they had been found to be in violation of certain anti-money laundering rules. According to the SEC findings, for about 10 years, ES Financial had maintained a brokerage account for a Central American bank that was trading for its sole benefit. They failed to create and maintain customer account records and provide them to the SEC representative upon request. They had also allowed a number of non-US corporate entities and non-US citizens who were beneficial owners to execute millions in securities transactions through that Central American bank and their brokerage account. So ES Financial didn't collect, they didn't verify, they didn't document any of the information regarding the identities of these non-US customers. They failed to comply with record keeping, reporting, record retention requirements, and other regulations that were implemented under the Bank Secrecy Act, including the requirements of the Customer Identification Program rule, which are applicable to broker-dealers. So in response to the SEC findings that they had violated these anti-money laundering rules by allowing these foreign entities to buy and sell securities without verifying their identities or the non-US citizens who had beneficially owned them, ES Financial agreed to pay a $1 million penalty to settle these charges. So without admitting or denying the findings, they agreed to refrain from committing any sort of future violations and to also have their anti-money laundering and customer identification program policies, procedures, and practices independently monitored for the next 2 years. And just a quick note, under the proposed rule, maintaining an adequate customer identification program, it's not yet a requirement for registered investment advisors, but it is likely that this requirement will be added later by FinCEN. Okay, next case involving Thomas E. Hayter. In this case that I'm about to review, it involves one of the first cases against the Chief Compliance Officer for failing to maintain an effective AML program. In this case, it really highlights how enforcement actions are not just limited to firms and can and have been individually brought against AML compliance officers by regulators due to their important role and their function. So in late 2014, FinCEN had found that Thomas Hayter, who was the former CCO of MoneyGram from about 2003 to 2008, that he had failed to adequately supervise the firm's AML program. FinCEN had alleged that Hayter had responsibility over the firm's AML program, and as such, he had neglected to maintain adequate compliance policies and procedures, that he had failed to terminate suspicious agents, did not respond to a number of consumer fraud reports, or even ensure that necessary suspicious activity reports were internally filed. MoneyGram, the firm, they settled and they agreed to pay $100 million. Hayter, as the CCO, was individually and personally fined $1 million by FinCEN. This civil monetary penalty against Hayter was based on his failure and in his capacity as CCO to implement and maintain effective AML programs for MoneyGram and to file suspicious activity reports on a timely basis. So in addition to seeking this $1 million civil monetary penalty, FinCEN also sought to bar Hayter from the financial industry as a whole. So, I mean, these are just the sort of risk investment advisors really need to be aware of. Under the proposed rule, a designated AML compliance officer can also be an officer of the registered investment advisor. And as such, investment advisors really, they should keep these cases in mind. Pinnacle Capital Markets, LLC. This last one really highlights a scenario where a broker-dealer was duly sanctioned by both the SEC and FinCEN for AML deficiencies. In 2010, the SEC had charged broker-dealer Pinnacle Capital Markets, LLC, with failing to identify and verify the identities of its customers and to document its procedures for doing so. With almost all of Pinnacle's customers residing outside the United States, the SEC had found that from October of 2003 to August of 2006, about 3 years, Pinnacle did not verify the identities of a majority of their corporate account holders. The SEC also found that from October of 2003 through November of 2009, Pinnacle did not collect or verify identifying information for a vast majority of the beneficial owners of sub-accounts that were maintained by Pinnacle's omnibus brokerage accounts. So, according to the SEC findings, Pinnacle's documented procedures really differed material from what its actual procedures were. The SEC charged Pinnacle's officer, who was responsible for the firm's compliance with AML obligations, with causing Pinnacle's violations. So Pinnacle and the managing director were agreed to settle with the SEC enforcement action without admitting or denying the allegations, and Pinnacle paid $25,000 in financial penalties. In a similar and very separate parallel regulatory action, FinCEN found that Pinnacle had violated the Bank Secrecy Act. FinCEN's enforcement action found that Pinnacle's violations occurred between October of 2002 and September of 2009. And there's a litany list of Pinnacle's failures that we'll go through. Pinnacle had failed to implement adequate procedures and internal controls for detecting and reporting suspicious transactions. They had failed to establish adequate procedures and internal controls that were designed to ensure compliance with the Bank Secrecy Act. They had failed to implement independent testing of the AML program. And once they did finally implement such testing, they failed to identify the deficiencies. They had failed to implement ongoing Bank Secrecy Act training. They had also failed to establish and implement a risk-based due diligence program for corresponding accounts. They had failed to require custom identification program information for those sub-account holders who were affiliated with foreign financial institutions that had open master accounts with Pinnacle. At the end of the day, FinCEN assessed a $50,000 civil penalty against them, and half of that penalty imposed by FinCEN they found to be satisfied by the payment of the $25,000 fine by and to the SEC. So these are just a few cases to really keep in mind and kind of hit home the importance of making sure that you have a proper AML program in place, and that if you do have a proper program in place, that you're following through with what you say and what you're outlining. So what are some potential additions to this already lengthy rule? Let's see. Based on discussions that are out there, some of the contemplated additions to the rule could be, for example, let's say the addition of state registered investment advisors and other SEC exempt investment advisors to the overall general definition of investment advisors. Basically, what they want to do for purposes of the Bank Secrecy Act is they want to make sure that if you present a risk for money laundering or terrorist financing or other sort of financial crimes, that they're capturing you under that definition. Another one is, again, the highly discussed customer identification program requirement. It is anticipated that through a joint rulemaking with the SEC, that this customer identification program will very likely be added to the proposed rule. It's also expected that FinCEN will propose restrictions on U.S. correspondent or pay-through accounts for foreign financial institutions and on shell banks. There has been discussions that they're looking for a more comprehensive information collection of information and increased due diligence with respect to investor accounts. And lastly, it's contemplated that FinCEN may standardize requirements about performing investor due diligence and determining ultimate beneficial owners of investor entities. These are just a few anticipated changes. Again, as regulatory reforms occur or as future concerns are highlighted, it is likely that there'll be further discussion and review of what additions would make sense to be added to this rule. At this time, I'm going to pass the presentation back to Pat, who will conclude with some highlighted areas that we really hope you took away from today's presentation.
Okay, thanks, Sabrina. And before I wrap it up here, we've received a few questions that I think we touched on, or you two touched on as you went through your presentation, and maybe it makes sense to just look at some of those questions, and then we can wrap it up in about 5 minutes. But I guess the first question is just asking about whether the proposed rule, when it becomes effective, would apply to exempt reporting advisors. For example, a firm that is claiming the private fund advisor exemption from SEC registration. Hello?
Hi, Pat. Sorry, this is Wendy here.
Yeah.
This doesn't apply to exempt advisors. So this wouldn't apply to them. It only applies to registered advisors and those that are required to be registered.
Okay. And then how about for those that have an AML program that their administrator has in place? So working closely with their administrator, is that covered under the rule, or is that something, or I guess does that cover the firm under the rule, or is that something that would not necessarily be the answer, but it could be a piece of the solution?
I mean, it's a good question. If an investment advisor is already found to be duly covered under another AML program, either if they're, under a broker-dealer relationship, you don't have to create a new AML program, but you do have to add new requirements that are part of the proposed rules, such as suspicious activity reporting and the currency transaction reporting. The basic rule of thumb is that if you have an AML program in place, you need to make sure that it's compliant with the most current rule that's out there. So once the rule becomes adopted and finalized, investment advisors will need to review whatever AML program they're falling under and make sure that it's following through with all the proposed new requirements.
Okay. And I think going back to the first question about whether someone is covered under the rule or outside of the rule, I think I would just add that we're all sitting here on the phone today, many of us representatives of registered investment advisors, the type of institution or entity that does not yet fall under the definition of financial institution, yet I expect many of you have already adopted some level of an AML program with varying degrees of support from a third party or from your administrator. And I think one thing to consider is that as you think about this rule and what applies to you, is that the reason why many of you have already adopted some level of an AML program is because of your contractual obligations with your counterparties and frankly, the way that the industry has evolved, with many of you being on the front lines in terms of taking in your investors and making sure that you've got a program to document who they are, where they're coming from, what jurisdiction they're coming from, as well as the jurisdiction that their banks are housed. So, just a few thoughts as you think about, call it best practice AML programs, an AML program that's designed in reaction to contractual obligations with your counterparties, or an AML program that is absolutely required as a result of the rule that we're talking about today. So just a few degrees for people to think about. A few other questions for Sabrina and Wendy. Do you know of any software solutions that are set up to detect and monitor for suspicious activity?
Hi, Pat. This is Wendy. I don't have any actual solutions in mind, but there are software vendors that provide you with the ability to detect suspicious activity based on logarithms. They create suspicious activity reports that can be automatically filed with FinCEN. So there are software solutions out there. I don't know any off the top of my head, but whoever submitted that question, I can certainly get back to you with some suggestions for specific vendors.
Okay. Okay, and then another thing that I think we touched on a little bit, but just to know your client's obligations and gathering documentation on the front end when bringing in investors, and that level of transparency is a trend that I think we've seen in the industry, whether it's tax related and FATCA or from an AML perspective. But under this rule, would advisors be required to include know your client policies in the AML program?
Well, right now, KYC policies, they fall under the customer identification program. So at this time, under the proposed rule, it would not apply to registered investment advisors. Again, we said this is an area that FinCEN is very, definitely looking at to address, whether it be in future rulemaking decisions with the SEC. I mean, generally speaking, most registered investment advisors, they already have KYC policies in place. It's prudent to have that in place when you're practicing or as part of your existing AML program or your outline of policies and procedures. So while it doesn't, it's not technically a requirement at this time, it is something and best business practice to have, and it is something that's likely going to be in effect under the customer identification program when and if that does become part of the actual finalized rule.
Okay. We did get a number of other questions. I'm sorry we don't have time to go through all of them today, but as I mentioned at the top of the presentation, we'll look at those and try to get back to people with answers, or else you can feel free to reach out to Sabrina or Wendy or to me directly so we can help you out. So in the interest of time, I just figured, I'll go through a bit of a conclusion here. I think, with the comment period for this proposed rule being closed as of November of last year, we're of the view that the rule, once further reviewed, it could be finalized in 2016. So I think the general takeaway for today is that each of you, or registered investment advisors in general, if you haven't done so already, take a look at the details of this presentation and start preparing in advance for the noted requirements and obligations under the FinCEN proposed rule. And you can see, some of the things to think about under the proposed AML requirements are just, changes in your policies and procedures. So if you have an AML policy right now, take a look at it and do, overlay to this rule and make sure that you've got all the specifics covered. Take a look at your disclosure documents or your offering materials. Many of those documents will contain some specifics around anti-money laundering and what's expected, whether it's in the U.S. or in other jurisdictions. Again, some synthesizing will be needed there to make sure that what you have in place going forward fits the rule. You've got the information sharing obligations that Sabrina went through, and making sure that you have those outlined and understood. And then, the due diligence of any suspicious activities, and someone asked a good question about the software capabilities, making sure that you're covered from that perspective. That's not really an all-inclusive list, I think, but given that you do have some time here, I expect that getting this rule to a finalized state in the first instance is going to take some time. And I mentioned earlier, oversight by the SEC, getting examiners trained and ready to come in and conduct examination of an AML program and a policy is something that will take time. So there are a number of dominoes to fall in this process, but there are some things for you to think about. Hopefully today's presentation has been helpful and given you enough detail to take a look at. Again, if anyone has any questions, feel free to reach out to us. Otherwise, this concludes the webinar, and I thank you for your time.
Thank you, Pat.
Okay.